Hello, everyone. I hope you're all doing well. Appreciate you all taking time this afternoon for a Learn at Lunch online. I know it's been a while since we've done these. All of us have been really busy, not just here, but obviously all of you have. And I promise we're going to do better. If you have any topics you'd love to hear about, do me a favor. Put in the chat something you'd love us to instruct on. Our goal with these is a once-a-month basis. Record them. They're CMCA approved, so you can get your credits. And really, they're quick and easy. I don't want these to be anything more than 15 to 20, 30 minutes at most, because I know you're all busy professionals. And I know that for those of you that are on, it's interesting and you want to hear from us on our take on these legislative updates for this year. So, welcome to the class. Um, I'm Clint Goodman with Goodman Law Group, for those of you that don't know me. And I've been doing this line of work since 2006 when I started with the first firm that represented owners. Boo. And then a couple years later, I convinced those partners to help me start a board practice area and have left there in 2010 and have had our firm ever since. So, this last session was busy, like the other sessions. Before I dive into that, I always know we need a laugh. So let me just start with a stupid law real quick. I thought my son Crew actually shared this stupid law with me recently. Let me see if I can pull up his text here. It was hilarious. And I don't want to do a disservice by just saying it from memory because I always screw that up. You have to you have to do it from the actual words, right? Where is it, Crew? Dang, I don't see it. But let's do a DUI law. Uh, hopefully nobody on here um, has had trouble with DUIs, but here's one. Driving under the influence is a serious offense that can have significant legal and personal consequences. But in Arizona, and I think some of you already know this, maybe most of you do. I was in Mesa Cop. If you commit a misdemeanor, including DUI, while wearing a red bandana or having uh, anything red on your vehicle protruding, under the old archaic statutes and laws, you could bump that up to a felony. So I don't know what the state was thinking. We had a laugh about this when I was a cop during a squad meeting. I was sitting there ready to run out for graves onto the street before I went to law school. And our sergeant actually said, guys and gals, don't write a DUI up as a felony unless it's a felony. Don't just bump it up because they're wearing a red bandana. I guess there was a cop in another district that had written it up as a felony using that stupid law because they just didn't like the individual and there was a bad altercation and they were wearing a red bandana. So stupid law. All right. Very good. That was 4 minutes. Hopefully you know something now and don't do DUI, but if you are, don't wear anything red. Law updates. In 2025, we have a couple of things. What I'm going to explain here is if you look at the chat in the Zoom, I've uploaded this handout. This is a PDF handout that you can use. You can share with boards, you can share with the management companies, you can share with anyone you want. It's just out there. It's public information. It's our version of the summaries and a nice clean way. And you also have uploaded to the to this Zoom chat our PowerPoint that we use for those of you that are attending for CMCA credit. Okay? So the written materials, I guess you could say. So and for those of you that attended, I also have Christian, if you can see that. She's keeping a role here. But for those of you that are CMCA, please let her know so you can get your certificates from her directly. There she is right there. Okay. All right. Without any further ado, what I'm going to say today, because we have multiple managers, boards, etc., this is not capital NOT legal advice. There's nothing today that's protected by the attorney-client privilege. So if I'm called to court to testify about what I'm saying today, this isn't privileged. I can't say and invoke some attorney-client privilege for one of my clients. Okay. So that means, and that's important for you to know because that means any questions you might ask in the chat, there's no attorney-client privilege there. If you have a specific question you want to protect by the attorney-client privilege, it's better to email directly to me so it's not part of this presentation. Okay. And my email address, Christy can put that in the chat as well. All right. So what I wanted to do with this handout, I'm not going to use the PowerPoint. PowerPoint's more robust, more comprehensive. But I want to go over this quick churn and burn. On the left column is the actual language of the statute, and on the right column, it is the summary. So there's really no, you'll see here, like for example, with Senate Bill 1039, you'll see all caps. That's the new language. You'll notice though under Senate Bill 1022, there's no caps, but it's this part here, okay? So what Senate Bill 1022 did, and these are all signed by the governor going into effect, um, it raised the small claims amount from $3,500 to $5,000. Now, in Arizona, it's important to know that there's different courts for different things. What we call that is jurisdiction of the court. If you have a homeowner that's not paying dues and the association needs to foreclose on the property, that's not something a small claims court can do. That's not something a justice court can do. That's reserved jurisdictionally for the Superior Court. So you have right here the small claims court, which is reserved for small breach of contract issues. You agreed to give me a used car for 3,500 bucks and you didn't. I gave you 3,500 bucks. Well, my 35 want the car. In this scenario, I'm just going to sue you for my 3,500 bucks back as a breach of contract. I can go to small claims, assuming we've got a contract. Okay. And that's small claims. They don't allow attorneys there. They allow attorneys in justice court, which is your next level, which increases the amount that you can sue over, and it increases some of the jurisdictional things you can sue about, but justice court can't do, they don't have the jurisdiction to handle real property disputes, like foreclosure, for example. The Superior Court, which is where everything we do essentially for foreclosure, for enforcement lawsuits, where we need to get an injunction against the homeowner, any major dispute over, let's say 20, 30, 100,000, $1 million dispute with a vendor or with whoever or whatever, all of that stuff is done in Superior Court in Arizona. They have the jurisdiction for that. It's called original jurisdiction. So that's a quick down and dirty on this statute. I don't have a problem with that. With inflation and everything else, I'm glad that they raised it from 3,500 to 5,000 to let people deal with their issues. It doesn't really impact us unless you have a management company that is doing in-house collections and they go to small claims, which is fine by us. And we want to make sure that the board leverages all of its tools before it comes to us. But it is a good thing in my mind, and I think most of us like the fact that they increased those limits for small claims. Senate Bill 1039. By the way, as I'm talking, if you have any questions, put them in chat. I'm going to continue with the presentation to get through these because there's only a few of them, and then I'll go back to chat to see what kind of questions we've got. With the caveat, again, there's no attorney-client privilege. Senate Bill 1039. This is, as you can see, the all caps, is the actual language. If a board records a meeting that is open to the members, the board shall keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request. So we already know that from the prior year statutes that homeowners can record subject to reasonable rules set on them by like no tripping hazards and don't put your phone recording in somebody's face and be harassing and dot dot dot. And that's reserved for other trainings. You can go on our website and see all the different trainings we've done on proper recording and proper rules to adopt. Okay. The statute then said that it just simply said, if the association records a meeting, whether that's audio recording, video recording, Zoom recording, whatever virtual, if a homeowner requested that recording, the association was obligated to give the unedited footage to the owner upon request. And obviously, this is open meetings, non-executive meetings. Um, but there was an unanswered question, right? Like, what happens when a homeowner requests a recording from 15 years ago, or from 5 years ago, or from 6 years ago, or from 7 years ago? And the answer was, well, sometimes the management company's like, we don't have that anymore. And then these homeowners would sue over that or would not make arguments about that. So this clarifies the statute. I'm really happy with this one because now we have a clear answer. You have 6 months. You can keep a recording after 6 months, but now you have express statutory authority to keep it for 6 months. And if a homeowner requests it 8 months, at 8 months, 9 months, 10 months, whatever, and you don't have it, you're good to go. Huge caveat on that though. I recommend, um, now again, not legal advice, but I think it's important that a board adopts a recording policy if they're going to be recording meetings and then destroying them after the 6 month mark. And make sure you have a records retention policy, is what we like to call it. It's very clear that the board can, after the 6 month period per the statute, delete the recording. If you don't have that and you delete it and then somebody asks for it, you still may have a legal conundrum. I'm not saying there's a good argument by the owner, but I'm just saying you don't want to retain us if you don't have to. I think some proactive work here might be better than reactive work. And just have a records retention policy. It's very easy to update, very simple form-based document. We have a flat fee for them. You can, and I think most firms do. So there you go. The next one, Senate Bill 1070. This is also a great statute. I like this change. And it's nice for a change. Sometimes we're very down and dark about the new changes to the law. So far, so good, right? Senate Bill 1070. So there's the express language in all caps. Basically, and I'm dealing with this right now, and a lot of you managers have been in this for a while, and maybe even some of you board members that are veteran board members have seen that, or maybe have experienced where there's a weird sliver of property in the common area of your association. This is dealing with single family homes typically. Sometimes it happens with condos too, by the way. But planned community, I'm dealing with one right now with a planned community. And there's a handful of them every year we have to deal with, where the assessor is assessing their taxes for that sliver, weird piece that the developer didn't take into account or did something weird and it just fell off of everyone's radar. No taxes are paid on it. What happens when no taxes are paid on real property? There's a lien, tax lien is recorded. If nobody fixes it, then at some point the government sells that tax lien at an auction. People buy those tax liens for a living. It's an awesome investment, tax liens, if you can get them. Because if after, let's say I buy a tax lien at a sale that's part of your real property. I buy that, and in order for them to make me whole as the investor owner, now they have to pay me back the entire tax amount plus interest. And that interest can be really high. So it can be a really good way to churn and burn money by using $100 to make $200 or use $100 to make $150. But you can see on a grander scale how that is literally a profession of a lot of people. And so these investors come in and buy up, they gobble up all these parcels. Sometimes they just wait to see who comes and pays them. But by a certain point, if nobody's paid them, the statute allows them to foreclose on that property. And if they foreclose and nobody responds, they get that property. It's foreclosure, and it's a fast process. It doesn't take years. I mean, it's just the law is the law. And what's a beautiful thing about tax lien foreclosure is when you foreclose, you're like number one on priority lien. So everything below you gets extinguished. That includes mortgages. So this is why investors love this stuff. Let's say I buy $1 million property. So I'm right across the street from Los Angeles. That's where my East Side office is. Okay. Um, let's say there's a million, now it's $3 million home up in Los Angeles in the foothills. For whatever reason, somebody didn't pay their taxes. I buy the tax lien, and for whatever reason, nobody pays me back. But there's a $3 million bank mortgage on there. When I foreclose, I get to extinguish everything, and then I take the property free and clear. That is how it works. So in this scenario, it creates massive problems for associations when some third party takes ownership of common area. You have to retain us to unwind everything. Now, the good news there is it doesn't extinguish the CC&Rs. It doesn't extinguish, and this is a great topic for another day. If you want me to do like a learn at lunch on what to do here, put in the chat and we'll tee it up, get CMCA credit for it. Um, and we'll do a 30-minute presentation on it or whatever it takes. But we unwind these things. Not only I do, but others, but it takes time, energy, and money to do it. And sometimes you get lucky and the investor realizes, oh crap, I was just buying and gobbling up a bunch of shit that I didn't really do due diligence on. But sometimes people want to be pains in the butt and will demand access and try to come in with bulldozers and rip up your streets or barricade and do all sorts of stupid stuff, all of which we can stop. But again, it takes time, energy, money, and we have to get them to sign a conveyance deed to send it back to us if nobody caught it along the way. Okay. Admittedly, that's a worst case scenario because normally if they default, they will serve the association because you have a lien and then they'll forward it off to us. But sometimes nobody sends off the information to the board or somebody served and nobody gets notice of it. Okay. Make sense? Good. This allows the association to buy the property in common area. Okay. Which is important because it allows us to short circuit any of this crap and get right to the heart of it to get these weird slivers back into the common area, properly value it, properly consolidate anything that needs to be consolidated, and move the community forward without all of these unanswered questions or weird slivers here, there, everywhere. Okay. The next one, political signs. What is a statute with and a year for legislative updates with additional political signs or political flag language or change to a new flag or something? So this, you can see, says a political sign under this statute, Senate Bill 1378, now means a sign or flag. Okay. So what does the political sign statute say? If you don't know this already, our website has keyword search. I know there's that fantastic book out there that CHDB puts out that, but if you don't know the statute numbers or whatever, I haven't seen a book for a while. I don't know if they still do it, but a lot of us have them. You can just type in go to my website. There's a resource right here. You can click on resources. You can click on statutes, click on Arizona. If you drop down, if you know what statute you're looking for, great. If you don't, you can just keyword search it. And this gives you all the statutes with political signs in it and highlights it for you. So I'm just going to go to 1808, okay? Here's the statute on political signs. So we know from this statute when it's election season, well, I'm not talking right now. When there's election season, people can put vote for Harris, vote for Trump. We saw this in the last election cycle. Um, in yards of personal property. And the only way that the association can regulate that is you can match what the county code or this county or city code is. Okay. But if they don't have, if the city, town, or county did not regulate the size and number of political signs, like what you normally see in somebody's yard, you can still limit the number as long as it did not exceed 9 square feet. Okay. All right. That's fine and dandy. We've got prior year's law updates explaining all this stuff. We should understand this. Great. And oh, by the way, without getting into too many of the weeds, you can only have those signs there within a set window of the election period. And then they got to go after the election's over. Now, what this statute does is it brings in flags. So is a flag that says Trump 2024, Biden or Harris 2024, RFK 2024, or now a flag that says, I don't know, who Gabbard 2020, 2030, I don't know, whatever. Come up with whatever you're gonna do, whether it's Republican, Democrat, Independent, or apparently the New American Party. Those are now considered political signs. Can they fly them? Arguably not if it's not relevant to an election year. But and by the way, there's other nuances to political signs and flags about free speech and other things. That might be another training you want me to dive into. But the whole point here is this statute now bootstraps in political flags as political signs, which this is the perfect example. This is the one statute I really think needed more explanation before it became law. Here's why. Okay, so we know shall not exceed 9 square feet, right? And now we know you've got these deadlines of when you can fly it, when you can't. So the election's done. If somebody's flying a political flag after the election, can we now demand that it be removed? I mean, yeah, the argument's there. That's number one. Number two is flags, how often are they more than 9 square feet? Now that it's a political sign, can we demand that be removed? Uh, Also, since a political sign is now and it's a flag, but what about the flag statutes that allow the association to adopt rules about how they're flying all those protected flags? Like meaning only, this amount attached to the dwelling, a certain height, placement, all that stuff that the statute authorizes from last year's training. A lot of unanswered questions that may require a lot of litigation, which means it's part of the Attorney Employment Act, really. I so the whole point here is just to like make you aware. Look, flags are now political signs, and I think that there's unanswered questions that the courts are going to have to address with this. I do think that if you are a community that has concerns about flags and political signage, and you have a policy that already addresses it, or you don't, but you want one, need to make sure you update it and provide guidance in what the board's decision is on how they're going to treat all of those questions. Okay. And don't just make it up. Have a qualified association attorney do that with you. Go get some quotes. Go with somebody you feel comfortable with. Okay. Senate Bill 1494, common expense liens, foreclosure threshold, super quick and easy. Before this statute, after you've done everything with your management company to try to resolve the debt, sending all your letters and blah, 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 that you have to do. And if your management company has additional work for you, they're doing fantastic. Once you get to that end, where really you've done everything you can and the person's still not paying dues, well, the next step is to kick it off to an attorney, right? For further collections. This statute says that the law firm cannot foreclose on a delinquent property unless the assessment amounts are $10,000, the lien amount's $10,000, or it's been outstanding and delinquent for 18 months, at least 18 months. The original, before this law change, was either 12 months or $1,200, whichever occurs first. Now the new language is either $10,000 or 18 months, whichever occurs first. So it does delay things a bit. I can see the reason why the legislature wanted to do this and why a governor signed it into law. This is much better than the alternative I'll explain in one of the failed bills. Um, like I said, but problematically, I think ultimately it does create some additional delay for you of an additional 6 months before you can move forward with foreclosure. And some of us, some of our communities, some of our clients really feel like they can't wait that long because they're a lot going on. And they need that money sooner rather than later, which means some more, even all the more important for you to select a law firm to do collections. It's very into the churn and burn, not the hold on to the account for a while. So HB House Bill 2322 is mixed use kind of cost allocation. This is also actually a good one for me because I think this helps solve some of the ambiguity in the statute. Under the condominium, and this only applies to condominiums. So under the Condominium Act, the default rule, if you don't know this, is really important. The default rule is unless your CC&Rs provide otherwise, the association shall, not may, shall pass back to any common expense that the association occurs that benefits less than the entire community. So in other words, if the association needs to go in and make repairs that only benefit one unit, two units, one building of the whole, um, the default rule is if the CC&Rs don't require the association to absorb that cost, which older documents typically don't. So the most of the time, majority of the time, is you exercise the condominium statute and you pass that cost back, you do the repair and you pass it back to those exclusively benefited. A lot of our condominiums, especially a lot of our older condominiums now, had over time perhaps absorbed those costs. And this is one of the most important tools we're using to ensure that that takes a huge line item off the condominium's balance sheet and they're getting those funds back. And I think it's an issue of fairness, really. Well, this statute, because the ambiguity was, well, that's fine and dandy for these residential units. But what about commercial structures in these condominiums with different types of structures and units, etc. And this makes it clear it applies to every unit in a condo. It doesn't matter if it's commercial or it's residential. It's you pass it back. So important thing. I'm glad they did this. I haven't seen this dispute too often, but this is the perfect example, I think, in looking at the legislative history of a constituent having this one-off issue go to a lawmaker and say this is a problem that needs to be solved for the entire state. And they felt like they needed to solve it for the entire state, even though it happens very rarely. But nonetheless, I like this statute. It takes out some of the ambiguity. Okay. All right. A few last minute points here. We're coming up on 30 minutes, and I wanted to promise to keep us at or around 30 minutes. The the bill, these didn't really go anywhere. So the one thing that actually this year that scared a lot of us, that would have killed collections, in my opinion, is there's a lot of these bills that die that we're glad they died. But the one that scared me and other law firms and board members and management companies the most was this one here. What this House Bill 2865 said was even if you go to court and win on a foreclosure, you can't get any attorney fees, period, which to me is absolutely bonkers because foreclosure is not easy. Not despite what some of these lawmakers think. Some of the lawmakers down there that were pushing for this bill thought that foreclosures just click, 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 done. So that attorneys for associations were just raping the courts on attorney fees. But what I think there's some oversight on is one, collections is literally the law itself is pretty self-explanatory, but the regulatory requirements of ensuring every penny is proper is a complete minefield of work that has to be done. So while the law is clear as to what can be foreclosed on and what can't be, ensuring that every penny met every statutory requirement, both state and federal, is a list that's longer than Santa Claus's naughty and nice list. It is massive. And so, just to give you an idea, 30% of my entire law firm of around 2,000 clients is collections, 30%. And the rest is, general counsel, litigation, insurance defense, plug it in for any HOA need, okay? But 80% of my law firm is collection staff because of all the compliance, all of the work we have to do. And it's not just me, it's every firm. So obviously, I'm saying this because the attorney fees to foreclose on to ensure that all of the T's are crossed and all the I's are dotted is significant. And the amount of manpower you need to do it is significant. So even on a default judgment, when somebody doesn't respond, the common request of reimbursement from HOA law firms is anywhere from $3,500, which is super low, to a total of like 8, 9 grand. And all of those amounts that we're submitting, we tell the judges it's reasonable. And it's up to the judge to determine what is reasonable. And those judges are declaring what the reasonable amounts are, and they are awarding those amounts. So the judge is the filter of this, right? To determine what is a reasonable amount. But for them just to completely take all attorney fees off, you know what that means. It's a free pass for anyone not to pay dues. Because when you send it to us, we're not talking about hundreds of thousands of dollars. We're talking about a ledger of, you know, in their minds, this much. $500 represents 2 or 3 years if the dues are low. $10,000, $3,000, whatever it is. And some of these lawmakers are like, why are you submitting a fee application for 3, 4, 5, 6 grand when the amount on the principal balance is only like a grand? That's totally outrageous. But they don't understand all the nuances that go into and all the work that goes into it. Because every time the feds or the state do more to change the law and require this type of notice by your managed company before it can go to us, this specific disclosure that has to be in all caps, bold, whatever. Literally, we have to confirm every one of those on every single penny. So you get what I'm saying. You do. But this scared us because it would kill collections. So for the first time in like over a decade, all of us HOA law firms that do this full time, with the exception of maybe one or two, actually got together. Surprise, surprise, unicorn, rainbow. We all got together. We actually all jointly um, hired a lobbyist to go down and lobby on behalf of us to protect the ability of us to get attorney fees and fee shift that to the owners that are responsible for it, right? So thank goodness. Um, I mean, there was some great work on behalf of our lobbyist. There was great work on behalf of the ACM, and there's great work on behalf of CAI. It was a joint effort. What's crazy to me is this House Bill 2865 was started in the House in Arizona. In order for the House to vote on it, it had to pass out of a committee first. So it passed out of committee. The House actually passed this. And then it went to the Senate. And the Senate, that's when we were all like, really like, oh, wow, this is nuts that this has gone this far. And so that's when we stepped in and really paid attention to it. And I think that as part of our attempts, we wanted to work together with everyone, including the lawmakers that dropped this bill, to help explain, because they don't do this work. They don't breathe this. They don't understand it. And frankly, if I was looking on the outside looking in, I think, why the freak are HOA attorneys charging that much for default judgments? It looks like just a form thing. It's all about education and explaining what we actually have to do, right? I think we made a lot of progress, not only with the lawmakers that became opposed to this bill to help kill it, but with the governor's office. And also, and this is like I said, with working with ACM, CAI, and our lobbyists, but also even with the lawmakers that dropped this bill. I met with him personally before he dropped the bill. There are several other HOA attorneys that met with him personally. They did a fantastic job meeting with him, talking with him. Some of you on this may know who those are. Um, Huge shout out to those that spent a lot of time on this issue. I mean, and I'll just say right now, like I know that Scott Carpenter spent time on it. I know Brian Morgan spent time on it. I spent a little bit of time on it before it actually dropped. But man, I think that, and our lobbyists spent a crap ton of time on it. Chad Meisen over at CHDB. Um, you know, this is one of those examples where I get kind of get warm and fuzzies because all of us came together and all of us were like, hey, yeah, let's help educate. And it was the honey over vinegar approach. And I think it made a milestone. And hopefully this will allow us next session to avoid a lot of these wacky bills because now as part of education, um, we can focus on making the statutes better, like most of those ones we talked about today, as opposed to educating as to why the language of what they're voting on would really screw everybody. So, okay. Well, that is, I guess for me, I am done presenting on this. Let me look at the chat now and do any Q&A. If a claim is submitted to small claims is under 5,000, but when we get into court, it's over 5,000, what happens? If the principal amount is under 5,000 and you're talking about additional amounts like attorney fees and costs, first of all, small claims doesn't award attorney fees because they don't allow attorneys in. But if your principal balance ends up being more than 5,000, you lose jurisdiction. So it's important to select the right court at the beginning. If you're going to file for 35, let's say that you're going to file for 49,999, that's your claim. And it's like one bite at the apple. It's not like you can sue in small claims for a $10,000 breach of contract for 49.99 and then go back on another lawsuit and sue for the other 49.99. You can't do that. It's like in the criminal world, it's double jeopardy. I mean, you get one bite, bring all your claims at once on this issue. And that's fair. You don't want to clog the docket. And attorneys can't do that in the other courts that attorneys are allowed to appear in. So don't file something if you think your claim is going to be more than 5K in small claims. And if you're worried about it, I think first you got to seek advice from your counsel to make sure you're good. But if you're worried about it, just go to justice court where you know you're going to be within the jurisdictional limits. And if you're worried about that, go to Superior Court. Justice Court awards attorney fees, and attorneys can play in Justice Court. Can't do that in small claims. Okay, for reviewing the recordings, I think we're talking about the recordings of meetings again. Can the homeowner request a copy on a flash drive so they can take it home and listen to it? So maybe an audio recording. I don't care how it's provided. Um, if you're falling into the statute, I mean, the statute on The actual plain language of the statute, if we go to association records and we go down here to see what the statute says about association records, it says let's see, all financial and other records of the association shall be made, this is the operative language, reasonably available for examination by any member, right? And then it goes on to say that if they want a copy, you have to give it to them and you can charge up to 15 cents a page. Well, we already know that a recording doesn't have pages. So this is a conflict in the statute. This statute hasn't caught up with electronic recordings yet. And maybe that needs to be addressed in future sessions. But um, if you're going to provide a copy of the unedited, okay, which I think you need to, it's faster just to do it that way than to screw around with them having to come in and examine, listen to it in office. Um, I, I think that any way in which you give it to them is fine. But I think that you need to have a records retention policy by the board so you know how you're going to give it to them, the methods. And because you just can't come up and say, oh, I'm just going to give it to you this way. If they disagree and there's nothing in writing as far as policy goes, there's no governing documents to tell you what you did is right, right? So if there's a particular board that has questions about this, I think that's a discussion they need to have with council, not in this forum. But those are some of my preliminary thoughts. And by the way, my preliminary thoughts on that are obviously subject to change based on the facts and circumstances of that community and those governing documents. So, I mean, if I were cross-examined on the stand saying, isn't it true you said you have to give a flash drive or you didn't care flash drive or whatever? It was like that was just one option. It depends on what the documents say. It depends on the association. It depends on those facts. Thanks, Amanda, for coming and joining us, even though you're a tad late. Um, okay, so
Mm, Any other questions in the group chat unless you received any direct messages?
okay, I'm seeing just more administrative stuff for Christy on the rest of them, but okay, and some of the suggestions for our upcoming Learn at Lunches. All right, everyone, thanks. I know it went a little longer, but this one obviously for law updates is pretty important, so sometimes it goes over. Appreciate your time. Have a wonderful day. And if you want any specific questions answered that fall under a attorney-client privilege or potential client attorney-client privilege, you know where to find me. Thanks, everyone. Have a wonderful day. Bye-bye.